We recently started a subscription system which ranges from 1 year to 5 years, and we provide discounts to students and young lawyers as well. So if you like our content, I would urge you to please subscribe, and please do speak to your colleagues, your friends, families who you think believe in the rule of law and constitution, and who you think will find value in what we do. And we will try to improve ourselves. As a subscriber, you will get access to a daily bulletin, and we publish some excellent special issues. And please do go back home and read our special issue that we are just publishing on the Bhopal gas tragedy. It's excellent. We have been receiving excellent feedback. And yeah, please do subscribe, and there are some more details about the subscription out at the desk outside. And thank you again for coming here.
Good evening, everybody, and please pardon the fact that I have lost my voice today. Justice Oka, who I have the pleasure of introducing today, is probably quite fed up of being introduced by me in leaflet functions. But the difficulty of introducing a person a second time is that you're tempted to leave out the essential information which you gave to the audience on the first occasion, in the unconscious belief that the same audience is in front of you. So I've tried not to do that. So I'm afraid you have to listen to me going through the basic facts once more. Justice Oka was born in 1960. He's a science graduate to start with, and then he did his law from Mumbai University. He was enrolled as a lawyer in 1983, and he started his practice at the Thane District Court, which really explains his approach as a judge, to my mind, because he has a complete grasp of the entirety of the procedure from the beginning of a case till the end. He always approaches any case that I have seen him do in the Supreme Court bottom upwards, by which I mean he looks at the pleadings first, the evidence next, and then the trial court decision, the appellate court, etc. And this is also explains why he has such deep respect for the work done at the trial court level. I found that recently on an occasion, he has suggested that the constitution should be amended so that a district court should not be referred to as a subordinate court. And this is a wonderful idea. The word subordinate is not at all appropriate for those who deliver justice to the majority of the citizens of this country. Justice Oka practiced in the High Court thereafter from 1985. He started his judicial career in 2003 in Mumbai. He became the Chief Justice of the Karnataka High Court in 2019 and was elevated to the Supreme Court in 2021. I have debated a little bit as to whether I should add this to his biodata because it's a controversial issue. Only yesterday I heard somebody castigate the concept of the collegium in another platform. Justice Oka has entered the collegium of the Supreme Court of India, a non-constitutional position as we are told often, but nonetheless extremely important on the retirement of the Chief Justice Dhananjay Chandrachud. Justice Oka has always been fiercely independent and plain-speaking, and doesn't hesitate to take the judiciary to task as well. Speaking on the 75th anniversary of the Constitution of India, he wondered aloud whether the judiciary had fulfilled the expectations of the citizens and proposed that it was time to conduct an audit of the achievements of the judiciary vis-a-vis the citizen. With those words, I would invite Justice Oka to make his comments on today's topic. Thank you.
My esteemed colleague, Justice Augustine Masih, Professor Dr. Upendra Bakshi, Justice Gautam Patel, Indira Jaising and Anand Grover, all those who are associated with Leaflet and Society for Constitution and Social Democracy, retired judges, senior members of the bar, and ladies and gentlemen. I am always reluctant to accept invitations to deliver speeches, and especially speeches where elitist crowd from Delhi will be attending. But when Anand tells me I have to make exception, in such functions, it so happens that lawyers who practice before me are given task of introducing me. And I always hear the introduction very carefully, because I always feel that at the end of the introduction, the lawyer will be tempted to say, here is a judge who doesn't believe in giving hearing to us. But I know Jaideep Gupta, I was sure that he won't do that. I feel privileged to be part of this function. As a student of law studying in Government Law College, someone gave me a book written by Professor Upendra Bakshi. And that was a very famous book, The Indian Supreme Court and Politics. Even till today, I have preserved a copy of that book. The day I got the book, I completed reading of the book. Thereafter, I must have read and reread that book. The most fascinating part of his book is his translation of Justice Krishna Iyer's famous interim order into common man's language. Perhaps it was the order by which Justice Krishna Iyer granted interim relief in the case of Indira Gandhi versus Raj Narayan. And since that day, I became fan of Professor Upendra Bakshi. I must have read several articles written by him, several books written by him. Most interesting part is, very often he has criticized the decisions of our constitutional courts. Speaking for myself, I always welcome such criticism. Such criticism gives us opportunity to introspect. And especially when a scholar like Professor Upendra Bakshi criticizes our decisions, it's really an opportunity for us also to learn and to look back. When Anand Grover told me that Professor Bakshi was invited, I accepted the invitation, as it is always a learning experience to hear Professor Upendra Bakshi. And in addition to that, I was told that my dear friend Justice Gautam Patel will be part of this function. Only one thing I am missing today. I remember last year I attended a function by Leaflet, and there was a presence of comedian. I think your function should necessarily have a comedian present.
You are asking for so much money.
And actually, you should insist on Raju More attending such functions. Because I am worried about one thing. So far, he has not written a single article on me. So maybe he's waiting for day of my retirement. Today I am here, perhaps only because I am judge of the Supreme Court of India, and therefore I am entrusted with the responsibility of making opening remarks. I must say that I am not an expert on constitutional law. I am and will continue to be a student of constitutional law. I have been a part of legal system for last 41 years. Out of 41 years, 21 years, I have been part of 3 constitutional courts. I have traveled from one district court to another in Maharashtra, one district court from another in state of Karnataka. I was fortunate to be chairperson of the Maharashtra State Legal Service Authority and had occasion to go to villages. I had occasion to visit prisons. I had occasion to visit Dharavi slum in Mumbai. The most wonderful experience for me was we conducted two mega legal aid fairs, and they were in extremely remote part of the state. One was in Mool, which is in Chandrapur district of Maharashtra, which is Naxalite dominated area. One was in very backward village of district Beed. And I got opportunity to interact with common man.
One thing which I realized was very few are aware that there exists Constitution of India. I remember my last mega legal aid fair in Mool. That was, I believe in February or March of 2019. What we did was, there are large number of schemes, welfare schemes of the government of Maharashtra. They are really good schemes for helping poor women, poor farmers. So what we did was, we requested our paralegal volunteers to go to villages, find out who are the eligible persons. We made them apply, and we ensured, after talking to the government officers, that they get relief. The point is, when we interacted with there were about 25,000-30,000 people present, everyone was completely unaware about the Constitution. We have clause A in Article 51A of the Constitution, which provides that it is a duty of every citizen to abide by the Constitution and to respect the ideals and institutions. If many of the citizens do not know what are the ideals of the Constitution, how will they abide by and respect the Constitution and its ideals? To commemorate 75 years of adoption of the Constitution, now we have so many functions in courts, in law schools, other institutions associated with law. I suddenly realized, I attended 2 or 3 such functions, I suddenly realized that for last 75 years, we have been discussing Constitution mainly in elite gatherings. We must be going to the villages, we must be going to slum areas, we must be going to rural part of India and discuss Constitution. If our younger generation does not know what are the ideals of the Constitution, what is the philosophy of the Constitution, ethos of the Constitution, how do you expect them to abide by the Constitution? With all my experience of 21 years as a judge, I feel that our emphasis should be to educate our children on the concept of secularism, justice, liberty, equality, and most importantly, fraternity. On completion of 75 years of our Constitution, the real need is to educate our masses on what the Constitution means and what the philosophy of our Constitution is. As Mr. Jaideep Gupta said, I repeatedly said that this is an occasion for all those who are associated with judiciary or judicial system to introspect on what judiciary has given to common man. I always believe that we should not be discussing what we have achieved. Instead, we should concentrate on what we ought to have achieved. I have been repeating one thing in every function. We have committed a biggest mistake during the last 75 years. Whenever such gatherings are there, functions are there, we discuss only constitutional courts. I have rarely attended any workshop, any such function where we discuss our district courts and trial courts. These are the courts of common man. And we are under mistaken belief that the fundamental rights of the citizens are enforced only by constitutional courts. There we are completely wrong. For establishing smallest right, common man goes to these courts, and we have never discussed how and in what manner we should ensure that our common man gets quality justice. It is for researchers to find out how how many litigants who file cases in our taluka courts or district courts, how many of them land up in High Court, how many of them come up to Supreme Court, we will find that the percentage will be very small. So when we complete 75 years of Constitution, our emphasis should be on discussing these common man's courts. We have to discuss the performance of these courts which exist at grassroots level. There are various issues which we must be debating and discussing about judiciary. As all of you know, entire data about pendency is available on National Judicial Data Grid. Now today we have some 4.57 crores cases pending in our trial and district courts. 58 lakhs or 59 lakhs cases in high courts and 82,000 cases in Supreme Court. This is not the only challenge which we face. The real challenge is today, after 77 years of independence or 75 years of existence of Constitution, there are large sections of our population who can't even think of approaching the courts. They silently suffer injustice. So one hand, we have this huge task before us, how to deal with these mounting areas. On the other hand, we must think about those citizens who just can't think of approaching the courts. We used to go to prisons. We used to go to villages, as I said. We came across several such people who don't know that remedy is available where they can go to the court and redress their grievances, or at least make an attempt to redress their grievances. When we discuss this, we always discuss those usual things: lack of infrastructure, there are so many vacancies, then the just to population ratio, which should have been 50 or 60, which today we are struggling at 23 or 24. But there are other issues which we must be discussing, which has direct correlation with fundamental rights of the citizens. Maybe I used to have some difference of opinion with Brother Justice Gautam Patel. We have shared division benches for quite some time. I always felt that we need to consider one thing very seriously, whether in our country we should think of giving priority to so-called commercial matters, whether it is necessary to do that. When we have such a huge pendency of small criminal matters, civil suits, someday we must analyze. I'll give you an example of one category of litigation where a litigant has no choice but to litigate. That one category is applications for succession certificate, probate, letters of administration. Somebody loses his husband, that lady can't get pension, lady can't get retirement dues unless she goes to the court. Please find out how much time it takes to get succession certificate. I am talking about middle class persons. And I don't know how many of you read a small article written by Uday Dandavate, son of Madhu Dandavate, that uncontested case, where Bombay there is compulsion. If you have property in Bombay, your smallest property, you have to go and obtain probate or letters of administration. He had complained that uncontested probate case took 4 years. I can give several instances where person must get relief. I'll give a simple example. Suit for partition. It's common man's litigation. Even if you have half acre of land, then there are sharers, there are Hindu families. Now today, if you go to civil court and get a decree for partition, the most difficult part is final decree proceedings. Because if it is an agricultural land, in view of section 54 of CPC, the partition proceedings go to revenue court. At least in 2 states I have seen, in Maharashtra and Karnataka. It is anybody's guess how many decades it takes. take a case of a matrimonial dispute. It's a very serious concern. Serious concern is now one matrimonial dispute leads to minimum 5 cases, maybe under Domestic Violence Act, maintenance under Section 125, then divorce petitions, restitution of conjugal rights. Unfortunately, if there are children, then dispute regarding custody. And then so many appeals, petitions. Look at the pendency of these cases in some of the high courts. Brother Gautam will remember, we used to take up family court appeals. Now we have so many matrimonial matters, and look at the impact of matrimonial disputes on the society. One matrimonial case, minimum 3 families get adversely affected. One is the small family of husband and wife, and if they have children, then it's worst. And then family of the husband, family of the wife. I'm just giving these few illustrations to just point out that now we have to think about our priorities. We must set our priorities right. There has to be a policy, which cases we are going to give preference. Are we going to give preference to only those cases who can afford to go to High Court or Supreme Court? So this is one area, and ultimately this is one area where we should be debating and discussing. Unfortunately, we don't discuss such issues. There's one more aspect which I just want to highlight before I sit down. One question which I always ask to myself: 75 years of existence of Constitution, is it really an occasion to celebrate? What are we going to celebrate about? Perhaps this is a good occasion for all of us who are associated with legal system to introspect and find out where we have gone wrong. And as I said, there is enough of discussion on Constitution, on fundamental rights, where so-called elitist people participate. We must go at the grassroots level and discuss what is Constitution, and discuss what is fundamental right and what is fundamental duty. I think the time given to me is over, and again go back to the same thing. If I don't give long hearing to lawyers, I don't expect them to listen to me patiently. And now the most interesting part of the function will follow, and therefore I must pass on the baton to Brother Justice Gautam Patel. All of us are eager to hear the conversation between Professor Upendra Bakshi and Justice Gautam Patel. Brother Gautam has a unique style, and he is going to ask many searching questions, and I hope that he spares me, because I am also I am eager to hear Professor Upendra Bakshi, but I am sure Brother Gautam is tempted to ask me a few questions. And I am sure that today's conversation will enrich all of us. I thank Anand and others for giving me the opportunity, and most important opportunity to hear Professor Upendra Bakshi. Thank you very much.
My second task today is more daunting, which is to introduce Justice Gautam Patel.
Which is most difficult job.
It is somewhat easier for me because I happened to meet Justice Gautam Patel a few minutes back. I and all of us, we know him through his delightfully written judgments, which I think we should recognize as pieces of literature. But coming to speak of him, I was looking for possible pointers that there may be something common in our experience, and I found 2. One is that he was a graduate of St. Xavier's College, and I went to St. Xavier's School in Calcutta. And the second one was that for some time he worked with my very old friend, Mr. Janak Dwarkadas. Justice Patel was born in 1962, And he started his practice in 1987, and he built up a practice in commercial, corporate, and civil laws. He took special interest in issues relating to environmental law and civic issues, as a result of which he, in 94-95, I believe, he was granted the first international fellowship in environmental law at Sausalito, connected with the University of Berkeley in California. He has had occasion to teach. He has been a lecturer from 2008 to 11 in the Government Law College in Mumbai, where he taught administrative law, constitutional law, and of course, his first love, I think, environmental law. He has written extensively. He has had weekly newspaper columns. He has contributed articles to scholarly journals like the EPW, the Economic and Political Weekly. He served as a judge of the Bombay High Court from June 2013 to 25th of April 2024. He passionately believes, as I can see from his writings and his judgments, in the right to dissent, and has refused to use law to gag, silence, suppress, and subjugate the citizens of India. The second task I have now, I don't have the temerity of trying. That is, I was asked to introduce Professor Upendra Bakshi. I said I'm not going to be able to do that. So we have requested Justice Gautam Patel to introduce Professor Upendra Bakshi to you.
And typical of senior lawyers, I was told 3 minutes ago. And since Justice Oak bemoaned the lack of a comedian in the audience, let me assure you all is not lost. I'm here. The essential, Justice Oak, I'm taking this opportunity, is something that you do not know. Even his clerks don't know. So let me tell you this. There are many, many things. Justice Oak is, I think, one of my closest friends. We've seen each other through very difficult times. But the very last case that Justice Oak argued before the first court in Bombay was against me on an environmental law issue. And I'm very, very happy to tell you and to remind him, which I never fail to do, that he lost and I succeeded. And a few months later, he became a judge. Now, if you've ever been mentored by Justice Oak, you know that your life has two periods. It's before Justice Oak and after Justice Oak. And you never really recover from the mentoring by Justice Oak. So all of you out there who think that you're going to forget this in the past, it's not going to happen. But the importance of this discussion this evening, I think, is that we very seldom get to what I think is a very important intersection between academic thought, which is analytical, and the judiciary, because once we are here at this intersection, we are really discussing issues of concern across a very wide spectrum. We are not assailing this or that judgment. We are looking at subjects. And this is where Professor Bakshi's contribution is, I think, inestimable by any measure in the body of work that we've seen in Indian jurisprudence. We've had academics who've written on this or that statute, but if you look at Professor Bakshi's range, from environmental issues to feminism to gender equality to constitutional issues, it is breathtaking and staggering and very humbling. You cannot help, when you're in the presence of someone like Professor Bakshi, to not feel awed at the sheer learning and the intellectual power that is on display. I must tell you on another side note, since I said this was comic, in the last 10 or 12 days while these conversations have been going on between Indu, Anand, Professor Bakshi and myself, I discovered that Professor Bakshi, unlike counsel who are used to thinking on their feet, and judges to whom it really doesn't matter what they say because they're saying it, Professor Bakshi wants it scripted. What are you going to ask me? How am I going to respond? And I took a sort of wicked delight in telling him, I'm not telling you. So you figure it out. So it is with that that we are going to approach this. But it's a time also for a very somber reflection. And I do want to start here because I think it's important. 35 years ago, my friend Salil Tripathi, a journalist, a writer, an indefatigable champion of human rights, wrote this. She no longer has tears. Her child didn't get the time to cry. She stares at the silent sepulchral skeletal plant where that cloud had emerged that night, when to breathe was to die. Today, 4 full decades on after that catastrophic night in December 1984, Salil and I have fewer questions than we did in our younger and more idealistic times. But our questions have multiplied. There are, I would suggest, 2 catastrophes. The industrial disaster itself is the first. And how we collectively as a society, and I mean all of us, not just the government or the judiciary, failed to deliver justice is the second. And therefore I think it is appropriate that I begin with remembering Bhopal and putting this to Professor Bakshi. For this is a subject on which, Professor, you have written much. So let me ask you this. From that terrible night to today, a span of 4 decades, in your view, what would you say are the 3 most critical failures in delivering justice?
Thank you, Dr. Patel, and thank you, Justice Oka, for your kind remarks. I must also thank Indra Jai Singh and Anand and the Leaflet community and all distinguished justices and friends for this gracious invitation. This week began from December 2 to Human Rights Day, December 10th. It's the week where we put the constitutional values last. And that is one thing about Bhopal. Such a big catastrophe. In fact, it's a series of catastrophes which re-victimizes the victim. My mind goes back, thank you for bringing Bombay to a place called Delhi. In a sense, I recall my days in Government Law College. And I'm very happy to be here with the auspices of Bombay in Delhi. So I'm glad. But talking about Bhopal as a series of catastrophes. And there's an old song rendered to music by Naushad Ali Khan. It says, जहाँ खुशी के साथ दुनिया में हजारों गम भी होते हैं, जहाँ बजती है सहनाई वहाँ मातम भी होते हैं. When the trumpet blows, there is funeral dirge as well. And Bhopal, number 1, is a funeral dirge on Indian democracy, and I'm sorry to have to say on Indian judicial process. Second, the several cases of total gas leak. My blood boils when people call it a gas leak. As the Bhopal Act, which in the Judicial criticized and Circa criticized, did. It was a 47 tons of MIC that visited 17 wards of Bhopal. I was there on the third day, from the third day onwards in Bhopal. And I know how many people died and how many were ultimately compensated, if at all. So the catastrophe is the first catastrophe is the actual release of 47 tons of MIC. The second is the catastrophe of judicial settlement by the Supreme Court, which forgot all about administrative law which it had developed. And a party to a suit had a right to be heard. The victims were a lawful party to the suit which came in appeal from Union Carbide from Madhya Pradesh to the Supreme Court. And the settlement orders were passed in chambers to the utter and dire exclusion of the victims. So that was the death. And in fact, I wrote an article there calling this a second Bhopal catastrophe. And my friends in the judiciary did not like what I had done. And they said so. They are naming me. But it can't be enrolled. The third catastrophe was the settlement, the way the tribunals compensated so-called the victims. So it is constant story of re-victimizing the victims. It is a constant story of struggle, and the exact novelist, I'll end with this, Milan Kundera wrote one of his books, begins with this saying, which I always remember when I talk of Bhopal. Milan Kundera said, the struggle of men, and I had the struggle of women against, for justice, is the struggle of memory over forgetting. I am very glad in a somber way that we are remembering the struggle. Struggle for human rights begins when people refuse to the cause of power, foreclosure, for forgetting, reorganization of memory. Is the name of power. Power of forgetfulness is the real power. Power of organizing memory. And brilliant victims of Bhopal have still for 40 years still remember this occasion. Sorry.
Thank you, Professor Bakshi. These are powerful words. Justice, memory, forgetting, forgiveness. All tied to this concept of power, but power over whom and on whom vests power. These are issues that we'll examine. Let me move, Justice Bakshi, to something allied, because otherwise we could spend the entire evening on Bhopal and not be done. Recent decisions of the Supreme Court have received wide attention: privacy, free speech, religious freedoms in particular. What is your evaluation of the Supreme Court's decisions, plural, not any one in particular, yet, on religious freedoms?
I would generally say that the overall performance in the field of human rights of the Supreme Court, the normative force of what Supreme Court have decided in terms of invention of new rights, in terms of invention of new freedoms, is A1. There are very few courts in the world which would reach this normative height. I immediately must say, repeat what Justice Oka said, that the normative feat of Indian constitutionalism just shows the gap between people and the constitution at the same time.
Specifically, which ones, Professor Bakshi?
Take the decision privacy, a natural right. Supreme Court speaks of a natural, no court in the world speaks today of natural right. A natural right which has become a fundamental right, which has then become a human right. And it is a right that pre-existed the Constitution. If you look at history, it's not the case. But if you look at sheer normative force of the idea of privacy, whatever be the social reality, but social reality totally against the idea of privacy. You don't have curtains, you don't have a house. You live in a basti, and you think of privacy, large number of people live there. They have no right to shelter.
So the Supreme Court has innovated, taken steps forward, made a positive normative
Absolutely.
contribution, as you
Absolutely.
say. But let's then go back over the last 10, 15, 12 years, so that there's some context to looking back, looking forward. Has there been, in this period, a steady attempt to whittle down critical components of the Constitution enough to have us worry about the future?
Well, it's a matter of balancing, normative balance again. You had the invention of the basic structure, which put the brakes, much needed brakes or limits on amending power in 368. I was in plane with Ram Jethmalani once, and he put his finger on his nose and said, "Don't talk." And I said, "Ram and not talk, it's not possible." He said, don't do that. I'm not your friend today. And he left the airport, I left the airport, but there were separate ways. Excuse me. And Ram was looking all the time on Article 368 and last words of it. Later on he told me, we were looking at this one, that, later on he argued that way. He said, blah, 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 this thing, that thing. The Constitution shall stand amended. And he argued, what did the words the Constitution mean, which shall stand amended? So there has to be a the Constitution, which should stand amended. And that the Constitution is, many people argued, is the basic structure.
So let's take these
And
three.
that article made all the difference. The Constitution shall stand amended. Supposing some other words were put. And that created the power of the words written on a parchment. This is why legal profession is known as communicative profession. What is communicated by the definite article.
So let's take the basic structure doctrine on which you've written extensively over a period of time. You have an understanding of it. How far do you think the Supreme Court is aligned or in accord with your understanding?
Supreme Court, I'm a small person. I cannot be aligned, Supreme Court cannot be aligned to me
Why not?
because it's Supreme Court.
It's
It
thought.
calls itself the Supreme Court.
It's thought.
It doesn't call it the summit court, it does not call it the final court, it does not call it the federal court, it calls it the Supreme Court. I'm always district court being called as not a subordinate court.
All right, let's not talk about the court. Let's talk about its jurisprudence.
Jurisprudence.
All right.
What does the court do? I think federal court is a wonderful idea, wonderful title. And Supreme makes a lot of difference. Sorry to go on. I won't go on. But anyway, that's Supreme Court. It's nice to be belonging to the bar of the Supreme Court. A Supreme Court, there's something supreme. It's only next to God. That I think is a final court is not necessarily supreme. Anyway, that's a different matter. Sorry.
On the basic structure,
Basic structure.
have you been misunderstood?
Basic structure uses, there are two phrase regimes that are used. Basic structure and essential features. And you ask yourself, what in the name of everything you hold dear is the basic structure? The answer is, it is the power to lay down what is the basic structure. It's a power to say what is, when a basic feature, essential feature is violated. The basic structure is the power to articulate essential features. That's what Keshwananda decided. And doesn't mean, even if an essential feature is violated, say Janhit case in 2023, this late, it says that even if an essential feature is violated, the basic feature may not be violated. Basic structure. So the interplay is between basic structure and essential feature. And I think the second aspect of it is that the Supreme Court in Nagaraj case has said basic structure does not apply only to amendments of the Constitution. Nagaraj clearly says 2006, it says it applies not only the provisions of the Constitution, but to the principles of the Constitution. So its range is expansive. So basic structure is the Constitution of India. I never do prophecy. I'm not in that business. By 1974, I wrote an article on Keshwananda Bharati, in which I said my beginning sentence was, the Keshwananda Bharati is not a case or controversy, but the Indian Constitution of the future. And so it has been.
Thank you. Well, your work on basic structure and its various facets has been quite, if I may use the word, expansive. For instance, you've written about feminism and the basic structure. For instance, saying Vishaka feminized the basic structure doctrine. And then you contrasted that more recently with the Supreme Court order referring Sabarimala to a larger bench, which you said was doing the reverse. Could you expand on that?
Yes, Supreme Court is, I beg your pardon, but I beg pardon of the entire assembly, yeah, but my views on the, and this is in the Kapila Hingorani lecture I gave some time ago also. I'll take a minute on this.
Yes, yes.
The Visakha judgment was pure judicial law making, and it said we are making a judicial law, and it made a judicial law which will be held valid under Article 141 till Parliament passes another law, and it was valid for 13 long years. Parliament did pass this was delivered on the eve of 50th anniversary of the Supreme Court. It was a gift to the nation by the Supreme Court. And Parliament still took 13 votes. Visakha has not been repeated. Instead, constitutional morality has taken its place. And constitutional morality I explained to my class when I was teaching in terms of a conflict between CM and PM. Now don't get me wrong, I don't talk of politics. CM stands for constitutional morality and PM stands for public morality. So it's not that CN and PM which were familiar with after Maharashtra elections or whatever. That was latest elections, I think. That took in my mind. A very small memory for tyrannical events. So no politics, please. We are British. I think the essential thing called CM and PM, and then our friend Bharato added an additional thing, quoting Vivekananda also, which I call PM1, public morality, pre-constitutional morality. Now, what Sabarimala did is truly my dear friends, should be pathetic. Against the dissents, articulate dissents of Ravindran Nariman and Dr. Ranjay Chandrachud, the tradition and the rules of the Supreme Court say that review of a decision, it goes to the same bench which reviewed it, which gave the judgment. And all the reviews were referred to a larger bench, 52 of them. The question of Muslim women going inside a mosque was referred to the larger bench. The issue of female genital mutilation among Boer women, Boer women, was referred to a larger bench, and so on. The issue of non-pastor women gone to far temple and pasty Gary is referred to larger bench. The Supreme Court did not have information, despite computers and all that. There were several judgments given. Sansara judgment, its own judgment, about Jain monks committing, Jain laity committing suicides within Asia. That was not referred to. Jain Abhishek, Mahabhishek, of a naked idol of the Murti. Can women do the Abhishek? And Madhya Pradesh can do. These are not, Supreme Court was never aware of it. In short, Sabrimala judgment is unwanted and gratuitous disaster, because it is functioning, it is asking whether what is essential practice of a religion is to be decided by a court or somebody else. And this was all these questions, about 9 questions were referred to a larger bench in the name of judicial discipline. Highest act of judicial discipline that you have seen in the Supreme Court of India, I beg your pardon, is a judgment which violates every judicial duty and canon of rectitude.
Thank you.
And I have requested several Chief Justice of India to publicly say, withdraw the orders of 9-judge bench if I have not succeeded. I have no difficulty in making this announcement in public, sharing with you. So it's a disaster, and I hope, like Supreme Court has power of life and death not over human beings, but over cases. In this sense, some cases never come up. There is a case where CBI was declared unconstitutional by Justice Ansari, Chief Justice of Ayodhya High Court, Assam High Court. What did he say? Just give me half a second more. He quoted Jefferson. Of course, in attributing Jefferson, he was quite wrong. My research tells me otherwise, but doesn't matter. He said that when people fear the government, the state, that's the end of democracy. And when the state begins to fear people, that's the beginning of democracy. That case is withheld by the Supreme Court for the last 15 years. It is technical grounds why the CBI is unconstitutional. It will never come up. People will forget, generations will forget. That's why I remember Milan Kundera. So another the exercise power of life and death over petitions. And lawyers are equally responsible for their petition doesn't come up, appeal, they should ask the registrar or somebody to look after it. But they exercise power of censorship over live petitions, which are then dead forever. I was in a case, public interest, my case, Lotika Circa and other people, which appeal against Sabanu, did not yet come up, and all the petitions are dead except me. And I'm shortly following them. It has not yet come up. Maybe then a relative case ultimately covers it. But we were there. Our petition never come up.
Thank you for your candor. And while we're on that, let me move on to an extremely hot potato. What are your views on the final result in Ayodhya?
Oh, it's a hot potato, it's not a hot potato for me. But I've been misunderstood and I will be misunderstood. Let me explain. It took long for Ayodhya to be heard, because I don't think it was translated from Hindi to English. It took 2.5 years. Justice K. repeatedly told people, including lawyers arguing and parties before him, that he is inclined to accept a property suit and debate it and examine. He is not examining the case of constitutional secularism. I make a distinction, by the way, between political secularism and constitutional secularism, which is quoted in a judgment called Bhopal. My articles have been quoted, by all the characteristics of difference have been noted down. Different matter that your reading fees do not include Bhopal. That's a pity. But there it is. There is a difference. I won't go into it. I have no time to go into it. What was the point? Say.
Ayodhya.
Ayodhya. So thank you very much. Chief Justice K. tried a property suit. Property suit under TP Act has to be judged by criteria of transfer of property, whether you can prove your preemption or you can prove your title. Right or wrong, we may disagree with the judges, but judges held on evidence that the other one side was not able to prove its title. So title suit decided. In deciding the title suit, and that's where I've been very proud, they went into the Allahabad High Court judgment and they said that you must give twice the amount of land to the other side, to one side. To 2.5 acres to 5 acres. They said the destruction of the boss was criminal, and they instigated a criminal suit against, and they extended the first time in history. A judge was hearing the suit for 3 months or 4 months more to continue hearing the suit. Criminal complaint of destruction. Although he technically retired, he was continued by the order of the Supreme Court. Only order in Supreme Court has passed. So they have done, they have gone further. My only regret with Ayodhya is that even after they decided title suit, they decided to give 5 acres to the other side. They did not follow up. And my disagreement with the outgoing Chief Justice and his bench on the idea of on the definition of places of religious worship act cannot be greater, because Supreme Court there opened gateway for 3,000 or more places. And now you hear in the newspapers that Ajmer Dargah is being opened. This is not the idea of the act that was passed by Parliament, and this is plainly and manifestly against basic structure. So there are many developments which I don't agree with, and I think go against the basic structure, and I've written about that. But I cannot fault the original of their judgment. That's where my friends misunderstood me, and I have very, very few friends now left. That's all right. But I don't speak for the Supreme Court. Who am I? I only read judgments carefully, and I believe in socially responsible criticism. Not that those who disagree with me don't follow it, but I read the judgments. Many of my friends have certain preconceptions or appear for the one side or the other side in the case, in courts. And therefore they make up their mind very quickly. It requires me a lot of study because unfortunately or fortunately I read the judgments. That's the problem with me, and I'm paid to think. You know, which country pays people to think?
Well, not us and not very well. So all right, let me move to another thing, because
Yeah.
this is equally worrying. You know, a close friend, a senior lawyer in the Supreme Court, recently said to me, in a fairly uncharacteristic moment of gloom, that for the future we should all plan on spending some time in jail. We were talking about recent trends. It's all hugely controversial and quite worrying. Bail, no bail, which is the rule, which is not the rule. UAPA, PMLA, Bhima Koregaon, Umar Khalid, Sai Baba, goes on. My question to you, Professor Bakshi, is are you seeing or discerning a pattern here?
Well, I asked myself the same question. I'm glad you asked it. If you think of many countries in the world, and you think of civil wars, and so on, and then you think of human rights. You mention Iran, where some people were caught traitors and thousands and shot dead. There are many countries which cannot lisp even the alphabet of rule of law, let alone take rule of law as justice, or talk about basic structure. So we must take a perspective. We have a security state. The Supreme Court has adopted since 1950 preventive detention, not punitive detention, preventive, in all courts. And all the security legislation since then have been upheld by the Supreme Court, into the draconian ones. I won't mention the legion of them, but into the Public Security Act of Jammu and Kashmir. You have to see it in order to believe it. These are, and law reform commissions and all those judges, courts have upheld it. Why? I wonder why. And the reason I found is that right to collective human security is recognized as a human right. Collective public security, not just law and order. My reading of these cases suggests, judges are not always explicit, but my reading of the discourse suggests, close reading, that without human right to collective security and order, there are no fundamental rights. And the global experience suggests. You think of Gaza, you think of Israel, and you think of hundreds of civil war situations. Therefore, I think there is also a reminder to people that with all its public interest phases and manifestations, the Supreme Court and all the high courts are also, and also matters, what also matters, are also faces of sovereign power of the state, which you have forgotten. The activists have forgotten. Executive, legislature, judiciary. There are three powers, three faces of the state. It's only social accreditation, public interest accreditation. The courts are essentially part of the sovereign democratic Indian state. They are not social movements. They are not social movements. They might have progressive face, but they partake of the sovereignty of the Indian state, and rightly so. So collective security is considered a fundamental human right. And we would not need much lessons, we just to visit Number in Bombay. And
Let me pick up on that, Professor Bakshi. We'll run out of time shortly, and
Yeah, sure.
there's time for some Q&A.
Yeah.
But at the risk of seriously stepping out of my crease, I'd make bold to suggest that benches of the Supreme Court recently, Justice Oak's bench, the one that he's been heading, is very much in my mind, have been significantly in the vanguard in steering that jurisprudence on bail back to its fundamental constitutional underpinnings. He has navigated very difficult waters with courage, skill, fixity of purpose, and above all, he's done it quietly. So it's fair to say, I think, that he has undermined the earlier undermining of constitutional precepts. That trend from the Supreme Court is heartening. Justice Gavai's bench also has been quite vocal about rights, and other benches, we are seeing this on a daily basis. The tragedy here seems to me that any of this was even necessary. So let me ask you this, Professor Bakshi. Is our constitutional jurisprudence being threatened by a state-driven culture of instilling fear in citizens?
Which citizens do you have in mind? Rani Palkhiwala said during this internal emergency of 1975-76 that freedom exists in a small space called the Supreme Court of India. Outside this, once you step outside the Supreme Court of India, you can't speak up, you can't argue, you will be detained. You will be subject of manifold tortures. So, in a sense, the work of lawyers and judges, not common people, Justice Oka. It is the work of these normative harmonic professions on which our freedom depends. Including of those, our freedom depends on the work of hermeneutical professions which take leadership about the meaning of the words. This is the plain fact. And of the High Court, 9 High Courts, we should never forget, did not do what the Supreme Court did in the habeas corpus case. 9 High Courts spoke against. So progressive judges is the best hope there is for Indian democracy. And progressive political actors are the best hope there is for Indian democracy. And progressive public, progressive means what? Those who put in the language of Leaflet, the Constitution first.
I don't know if this is a view that is bleak or heartening, so let's just take this to where I want to take it. Where do you envision our country under a constitution 100 years after the constitution? India 2050.
Unless we are vigilant, in one word, against inconceivable constitutional dictatorship. Constitutional dictatorship of the highest order that you can't imagine. This is not only for India, this is for entire world. And that is because we live already in algorithmic society, in AI society, AI of various types. And my favorite writer who has never gone once wrong in his prophecies, the scientist, the computer engineer, Ray Kurzweil. He wrote in 25 years ago a book called Singularity is Near. In 2024, he wrote a big book calling Singularity is Nearer. And his prophecy is that by 2038 or something, the human machine learning non-biological intelligence, super intelligence, that the highest form of AI, super intelligence, will outstrip the biological intelligence. And therefore, who controls these inventions and corporations? Privatization of law and justice is a reality. As Justice Oka's own judgments, if I may refer to them, on privacy and bail conditions are now Google PIN. Police have made it increasingly everywhere a condition of bail. And Justice Oka and his brother judge have occasion to thunder privacy at them, that you can't add conditions which are not germane to the idea of bail. Now this is very important. We live already in algorithmic society. What will be the digital constitutionalism be like?
That's an interesting concept, digital constitutionalism.
Digital sovereignty has come to stay. Digital constitutionalism is the name of the next 10 years. We are already too late.
But this is of real concern to some of the people here because they are young lawyers, young academics, activists who are interested in constitutional law and human rights. So I'm sure that they will take this to heart. But let me end now because I think we must be running out of time. On a personal note, it's a safe place for me to be because my innings is over. What are the three things you would say every citizen wants from a judge in the Indian judiciary at any level?
Spine, spine, spine.
Thank you. Thank you.
I must also thank all of you, but thank Justice Oka. It reminded me of for reading my book and have the impertinence of rendering Krishna, Brother Krishna, Krishna judgment into simple prose, which is last and majesty. But he inadvertently reminded me of a rookie law professor at Delhi University, and it was my custom to call on the Chief Justice as a citizen, some refused and some welcome. I was not a known commodity as much as notorious I am today. But he was very kind. Mrs. Ray, Ajit Nath Ray was the Chief Justice, outgoing then. And when I went to visit him last, he was packing his bags in Krishna Menon Marg, and he took me to a room full with trunks and huge trunks. And he said, in this trunk are all the operations of the books and the articles, including those written by you. I'm taking it to Calcutta. And now that I have retired as Chief Justice, I read them with pleasure. So much about scholarship and judiciary.
Thank you so much.
We can carry on listening to this conversation, but I was taught early on never to stand between a judge and his lunch, but we are standing between us and dinner for the panelists. But we will take a few questions. I mean, I have hundreds, but we have to keep it very brief. So I don't know how to do this. I don't know if people have written it down, or do you want to just ask a few and I'll try and
Pass the mic around.
pass the mic around and I'll try and edit it. But it seems while this is going on, Professor Bakshi, that in Hegel's contradiction between law as power and law as justice, power seems to be winning, for now at least.
For now, it always was. But for the progressive justice.
Yes. So, do we have anybody with a question?
Everybody wants dinner.
Yes, everybody wants wants dinner. But ask. So, I appeared in Bhopal matter yesterday, and I'm appearing in one tomorrow. But I wanted to ask you, you said this, and your statement certainly resonates. What's if I was to ask you, what could have been done, for instance, in the reform of the Criminal Procedure Code, the BNSS, in the Criminal Procedure Code, so that the 40-year wait for a judgment to be delivered in Bhopal doesn't happen now? Top 3 things that we could have changed in our criminal procedure last year, so that we can truly have an adjudication at least of the state punishing those who do wrong.
This is not a laughing matter at all, it's a serious matter. But I was told recently that we decolonize the criminal law. So you should surely find a relief there. There is a new criminal procedure code that has some Sanhitas. I wrote 4 articles which nobody read, but for my own pleasure I write. That's a different matter. But the Sanhita is supposed to have decolonized these delays and colonial law with side-on delays. So surely you would find an answer now.
I want to ask one question.
Yes, please, sir. I think the mic is right there, yes.
I want to ask you this question as eminent academician. What do you think about experiment which is going on in our country of establishing so many national law schools? Whether it has really helped the cause of education, legal education in India?
That's a very loaded question. But before I come to that, you refer to me as eminent academician.
You just have to accept that.
Justice Krishna wrote to me when I became first the Vice Chancellor of South Gujarat University. And I couldn't believe that Krishna was writing. I called him Krishna, but Justice Krishna, he used to write short letters, but I couldn't believe that he could have written such a silly thing like this. But he said, now you become eminent person, eminent educationist. And then he had a sting, as you always had. But remember George Bernard Shaw, who said, the more eminent a person has become, the more he or she has done to be ashamed of. The more eminent the person is, the more he has done things to be ashamed of. And that way, I accept your idea of eminence as according to Krishna. Now, your question was about national law school. They're called National Law School, and they're presided by no less than Chief Justice of India, in some cases Chief Justice of High Court. I would think of a nuclear cloud when I hear proliferation of national law schools. Maharashtra has 3. Every state in India has one. It's a good thing. They come in various shapes and sizes. Some are very good, and some should not have been at all in existence. But every state should have one, so it's a federal idea. So they are called national law schools, but not all of them are national international in character, as they should be. Not all of them pursue with the same rigor the highest standards which are mandated by no less a document than Constitution of India. Our Part 4, which nobody reads because there are very few cases, the fundamental duties to which you refer to. And one of the fundamental duties is on all citizens to develop a spirit of excellence in all walks of life. And I used to ask my class, what was the other? Because we must avoid the tyranny of the singular at every step. What was the other of excellence? And the answer was mediocrity. So when you pursue mediocrity, you are violating the Constitution. Next best will not do. You must make the best the enemy of the good. That's the idea. That's the idea of excellence. And from that point of view, I'm sorry to say that the bulk of national law schools are a cut above the law schools where we studied, government law college in Bombay, for example, where you taught. But bulk of the national law schools quite simply do not exert themselves towards excellence. That few who do, and one should be grateful for that.
We have a question in the
Yeah, Professor Bakshi, this is Jayaprakash here. One of the problems we are facing with the Bhopal case is that the victims who do not have the right to read evidence in the criminal case, for example, and because of which an appeal against the conviction of 2010 is pending before the district court for the last 14 years. And the same matter has been heard by over 10 judges. And before a judge completes the hearing, he or she gets posted elsewhere. And the hearing restarts all over again. And the process has been going on for 14 years because the CBI is not interested in pursuing the case. And the 14 years, most of the time has been taken up by Union Carbide representatives. And we don't get to have a say in them. Although the law is supposed to have been amended to help the victims also to assist the court, that is not happening in practice.
Yes, I was very facetious referring to the Naya Kanun, but I recognize the problem very much, and I think it is a question of having more books on the ground, as I said the other day to you. It's a matter of some eminent lawyers, some of whom are present here, to take up the challenge and to argue the case at the district court level, not to wait for it to reach New Delhi or Delhi, but to argue the case where it is, and to make a lot of noise, which only senior lawyers can make at the district court for the delay in proceedings. Obviously, it suits people in power to delay. Delay is not natural. Delay is caused by human action and by social processes. I have a whole chapter in my book called The Crisis of Indian Legal System on litigant court delays, court delays, lawyer court delays, and so on, all various types of delay. I did not republish that book called The Crisis of Indian Legal System. You can't republish the second and third edition of it. Crisis is since deepened. But the point is, we don't have senior counsel going to district courts and arguing cases where necessary. And we need to mobilize them for every surviving Bhopal litigation. They were there earlier on at the Bhopal matters, like in Judicial. But not everything is argued at the Supreme Court level, as Justice Oka said. Many matters languish because of power differentials at the district court. And this is a constant saga of re-victimization of victims. There's no reason in the world why this matter should drag on. It has to drag on.
I'll,
Dr.
no, just, we have to now, we'll have the conversation afterwards if we may, but I'll just ask, I think this has been a great example, to paraphrase your book, of a conversation as provocation, and I'll ask Ms. Indra Jai Singh, of course, who needs no introduction, to make the closing remarks. Thank you so much.
This is indeed a difficult task because the conversation has been absolutely riveting and I could see a lot of hands up. But, all right, as we come to the end of this conversation, I need to place on record that both Upendra Bakshi and I are uniquely placed to comment on 75 years of the Constitution. Ask me why. Because, yes, please ask. Please ask. All right, I'll answer it even if you don't ask me. The reason is that we were both born before the Constitution was born. And I'm not going to give away our age, but I do think it's unique that we have two people here present who were both born before the Constitution of India was born. And that gives us a position which is very unique to take a distant and yet critical overview of the last 75 years of the functioning of the Constitution. I think it's also a very liberating factor to be of a certain age, because it makes you lose your fear of judges. And it makes you feel, what the hell? If I don't get an order, I don't get an order. But I will speak truth to the judges.
Did you ever have fear of judges?
I've done it.
Not that. No, did you ever have fear of judges? Not that anyone recalls.
Did I ever? Well, it's been very difficult for me to train my juniors not to have fear of judges, okay? So when my juniors leave me, this is the one takeaway they take from me. Never be afraid of a judge, okay, if you really want to become a successful lawyer. So, and yet, I think Professor Bakshi and I come from very, very different standpoints looking at the same document. He is a scholar, an academic, and he knows that I have this point of difference with him, and me as a simple, pure, simple little litigator. Okay? I don't have the academic achievements to my credit that he has. But Upen, I'd like to tell you that there are vital differences between litigators and academics, and I think that we are the better ones. Okay.
Don't respond.
No, don't respond. I agree.
It's free legal advice.
I must
Don't
tell
respond.
the audience.
But anyway, all right, there's no better, there's no worse. You recited a poem which said there is unity.
No,
You
it's
said
not.
something, didn't he say
You
something?
said-
That poem he recited from a Hindi movie.
You said in the Times of India review of my book called Supreme Court and Politics, I did not know her.
Professor, you got
But-
free legal advice. Don't respond.
She wrote.
Well, I'm very
she
sorry,
wrote
but I'm very
that
sorry, but there's also
Bakshi has no theory of state. And I
okay.
said, who is this woman writing
Yes.
in Times of India? But from
Yes.
that I learned so much. So don't say you are a mere litigator, that's all. Sorry for interruption.
Okay, let's move on. Let me just say we need both. We need academics, we need litigators, and we need judges. So this was a little attempt to bring the three together. And it's important in my mind to have everyone on the table, so to say, and conversation between all of you has been very enriching. But I have to also say a few words about the leaflet. I heard P. Sainath once say that every professional must also be a journalist. Every professional must also be a journalist. Why? Because of the need to communicate what you're doing. Justice Oka said, how many people know the Constitution of India? How many? Because of this absence of communication. But where I disagree with you, Justice Oak, is that don't underestimate us. And let me tell you that we on this side of the bar, we have walked the streets. We have entered the slums. We have seen the life of the homeless. We have seen the life of the hawkers. Upen just told you that he was in Bhopal 3 days after the disaster. Who else was there? We were there. So the legal profession cannot be underestimated by judges. It is something that you need to take away from this meeting. All that we ask is listen to us with open ears. We do not want you to decide the way we argue. The privilege of deciding is entirely yours. The privilege of criticizing is ours. And we will continue to do that. And this is the reason why we have survived. This is the reason why Leaflet has been set up. Now, I ask this question to you. If the Supreme Court does not respect its own judgments, and this takes me to what Upendra Bakshi said about the reference to 9 judges in the Shabarimala case. It just so happens by sheer accident, Upen, that I was involved in each one of those cases. The Parsi woman who was told she cannot attend her father's funeral. Why? Because she married a Hindu. FGM, I was representing a woman who herself has been subjected to FGM. And the story goes on. And Shabarimala was hard fought. The judgment was one of the most wonderful judgments of the Supreme Court of India. Yet it was referred to a bench, not just of 7 judges, Upen, it was referred to a judge of 9 judges. And I asked in open court the question, why 9? And I said, is it because you want to overrule judgments of 7 judges? And the Chief Justice said, nodded his head. You talk about indiscipline, here's indiscipline for you. So I would like to know, if the Supreme Court does not respect its own judgments, how do you expect an ordinary citizen to respect the Constitution of India? This is the question that we have for our judges. It's so evident from the fact that the Places of Worship Act is not being respected by the Supreme Court of India, despite an exposition of the law in the Ayodhya judgment. At least one author I know has written an article which asks the question, are we on the brink of a civil war? Are we on the brink of a civil war? And when that question is answered, will the Supreme Court be called to account? Yes, it will have to be called to account when this question is asked, are we heading for a civil war? I hope not, and I think not. So, I'd like to end by saying that despite everything that I have said, there's a running thread through the last 75 years of India's history. The history of a nation is also the history of its laws. And the running thread is the thread of resistance. I do not know of a single day in the life of the Supreme Court of India where there has not been resistance. The right to life and liberty was resisted by Mr. Nambiar when he argued. The argument of the Supreme Court was resisted by Mr. Nambiar when he argued the A.K. Gopalan case. From then till today, we have been resisting the supremacy of the Supreme Court. And a book has been published by the Supreme Court titled Supreme but Not Infallible. And I think this is what I will take away from this conversation. And yet, I know we can't discuss matters which are sub judice, but we can discuss the past and we can discuss the future. I intend to live up till 2050, right? 50. And this is a threat, okay? But I'm an eternal optimist, and I'm constantly reminded of what Martin Luther King said: the arch of the moral universes bends towards justice. Thank you very much.
Thank you, ma'am. Thank you, the panelists, Justice Masi, I think Justice Bambani had left, for attending, Justice Chauhan. And now, as somebody from Patiala, I have the greatest pleasure in announcing that dinner is served and the bar is open. Thank you very much. Open, I said open.